So is it your view as well, as it was Mr. Sauer's, that, yes, the president could assassinate a political opponent and not be prosecuted for it if his party won't impeach him in the Senate?
I think Trump versus United States that you mentioned, Senator, now has addressed to some extent the impeachment judgment clause, and that is set forth in the opinion. It would be something that I would be bound as precedent to apply if I was to address.
With my hypothetical.
Welcome back to Freedom Forge. If you believe in truth, accountability, and standing up for the values that built strong nations, go ahead and hit that like button and subscribe right now, because today's breakdown is something you're not going to hear explained honestly in most places. Today, we're reacting to a Senate hearing that centers around a very serious and controversial legal question: presidential immunity. Specifically, the debate revolves around a Supreme Court decision tied to Trump versus United States and what it actually means for the limits, or lack of limits, on presidential power. Senators are questioning a judicial nominee about whether a president could, under certain interpretations of immunity, act in extreme ways and still avoid prosecution.
Sorry. Thank you, Mr. Chairman. Mr. Smith, I believe that a lot of the corruption that we're seeing in the administration and the White House traces back to a single decision of the Supreme Court granting the president immunity, absolute immunity when it comes to certain core functions of the executive, a qualified immunity as to other official acts. The only area where a president would be personally liable for prosecution would be purely personal conduct, which is hard to imagine what that entails given that the president is president 24 hours a day. You were part of the president's legal team defending the president, articulating the president's position in Trump v. United States. I want to ask you about that. In the Court of Appeals, John Sauer, one of the counsel for the president, was asked by a Court of Appeals judge, Penn in the D.C. Circuit, whether under your theory of the case, his theory of the case, a president could order SEAL Team 6 to assassinate a political opponent and not be subject to prosecution for it. Sauer's answer was effectively, that's right. Unless he were impeached first, he would not be subject to prosecution. Is that your view as well?
I think a similar question was also asked at the oral argument at the Supreme Court a few months later. I think the Supreme Court has now set forth a test in Trump versus United States that would address that hypothetical situation, which, based on my relationship, I might add, I think is outlandish, and I see no reason to think that that hypothetical would ever be a possibility.
Well, so is it your view as well, as it was Mr. Sauer's, that, yes, the president could assassinate a political opponent and not be prosecuted for it if his party won't impeach him in the Senate?
I think Trump versus United States that you mentioned, Senator, now has addressed to some extent the impeachment judgment clause, and that is set forth in the opinion. It would be something that I would be bound as precedent to apply if I was to address.
With my hypothetical, what's your answer? The president orders SEAL Team 6 to kill his political opponent, one of them, maybe several, uses the military to do it, so it's within the scope of absolute immunity. Is it your view that he is not subject to prosecution for that if the members of his party will not impeach him?
With that hypothetical or any hypothetical that you might try to pose, Senator, I would just refer to the test that the Supreme Court has set out.
I'm asking you your view, so just tell me yes or no.
Yeah, and I want to tell you that as a judicial nominee, I don't want to prejudge any case regardless.
Well, I'm not asking you to prejudge. I'm asking you to talk about your view and also what you argued, what you counseled the president in that case. Did you make the argument as a member of the president's legal team that, yes, he could assassinate his opponent if he used the military to do it, and if his party wouldn't impeach him, that he would be protected?
Yeah, so I can't get into any privilege conversations, as you know, due to attorney-client privilege, but I would refer you to the remarks that John Sauer had at the Court of Appeals and the Supreme Court.
Well, the remarks that he made were, yes, that's correct, he would be immune. So I don't hear any disagreement with you. Do you disagree?
I would disagree with your characterization of how he responded to that question. I think he said it was outlandish, would not happen, and that there would be a process to hold someone like that accountable. And I think the
process, the question from the judge was, if he were not impeached first, Is that your position? And that was Sauer's position. It sounds like that is your position as well. Let me ask you about a different part of the court's opinion, that is that the only area where he's truly liable is purely personal conduct. So let me ask you this. If a president uses their official position to enrich themselves, is he immune, or is that purely personal?
So Chief Justice Roberts asked a similar question at oral argument. I think counsel referred him to the...
I'm asking you.
Yeah, I want to refer you to the same place, the United States versus Brewster.
Don't refer me, just answer the question. In your view, if the president enriches himself through his office, is he immune, or is that purely personal conduct?
Yeah, so I think the United States versus Brewster decision
Okay,
said
you're not answering my question. Let me ask you a different one, see if you'll answer that. If a president took bribes to change the country's policy in the Gulf, purely personal or subject to immunity?
Brewster dealt with bribes, and in that case, the court said that a legislator could be prosecuted for bribery.
We're not talking about a legislator. We're talking about the President of the United States, who has immunity now thanks to your work in part. So let me ask you another question. If a president demanded money from a media organization in order to approve a merger, immune or purely personal conduct subject to prosecution?
Every hypothetical situation will be addressed by the test in Trump versus United States on what type of immunity would apply.
Yeah, so you're not going to answer the question. What if a president falsely arrested a sufficient number of senators such that he couldn't be impeached? Is there a remedy for that?
For each of these hypothetical situations, the Trump versus United States test would be applied.
Okay, the Trump versus United States test would be applied. So the president is using the military to arrest members of Congress to prevent his impeachment. What's the remedy?
In each of these hypothetical scenarios, Senator, the remedy is...
What's the remedy?
The court would go through the different types of presidential power that might be at issue. There's a different test for absolute versus...
He's passed the test. He's got immunity unless he's impeached. That's what the court has held. And he's not impeached because he can't be impeached, because he's arrested enough of the Senate to prevent his impeachment or even an impeachment proceeding. What's the remedy?
So, Senator, as I've said, for each hypothetical scenario you're trying to present, the court would look at the different tests that the Trump versus United States would present.
I'm just going to have to conclude here that you don't want to express your view on it, because I think it's a shocking view. I think it was a shocking view that John Sauer expressed in the Court of Appeals. I think it's a shocking view that you hold, that the president's authority is so profound that he basically is above and beyond the law, that there's no remedy for a president who would abuse his power the way we have already seen and I fear we'll see in the future. I think the Roberts Court will go down in history. That will be their legacy as having enabled the worst form of corruption we've ever seen in the Oval Office. And you'll be a part of the team that made that possible. I yield back.
Thank you. I would point out the implication that Mr. Smith came.
Now let me say this right from the start. This hearing is not just about legal theory. It's about power, accountability, and the kind of country we want to live in. And as I watched this exchange, what stood out wasn't just the questions. It was the way those questions were framed and the assumptions baked into them. You got a senator throwing out extreme hypotheticals. Things like whether a president could order military action against a political opponent and escape prosecution. And look, let's be honest. Those scenarios are designed to shock. They're designed to generate headlines. They're not grounded in reality. Even a nominee himself called them outlandish. But here's where I come in with my perspective. As someone who believes in constitutional order and strong but limited government, I think it's important to separate fear-driven hypotheticals from actual legal principles. Presidential immunity is not some random invention. It exists because the president has to make decisions, often difficult, often controversial, without constantly looking over his shoulder worrying about political prosecution. If every decision could land a president in court the moment he leaves office, then guess what? You don't have a functioning executive branch anymore. You have paralysis. Now, does that mean a president is above the law? No. And anyone trying to claim that is either misunderstanding or intentionally misrepresenting the issue. What the Supreme Court tried to do in this case was draw a line. They said there are certain core executive actions that require protection, because without that protection, the office itself becomes weakened. but they also acknowledged that purely personal conduct is not protected. That distinction matters. And yet, during this hearing, what you see is a repeated attempt to blur that line. The senator keeps pushing the nominee to answer yes or no questions based on extreme hypotheticals, ignoring the legal framework entirely. That's not about seeking clarity. That's about scoring political points. And let's talk about the nominee's response, because that's where things get interesting. Instead of taking the bait, he keeps referring back to the Supreme Court's test. He refuses to speculate on hypotheticals. He refuses to prejudge situations that don't exist. And honestly, that's exactly what you want from someone in a judicial role. You don't want a judge who reacts emotionally to hypothetical scenarios. You want someone who sticks to the law, to precedent, and to the framework established by the courts. But of course, that doesn't satisfy the senator. So what happens? The tone escalates. The accusations start flying. Suddenly, the argument shifts from legal reasoning to emotional condemnation. Claims that this doctrine enables corruption, that it puts the president above the law, that it threatens the future of the country. And this is where I think we need to slow down and really think. Because here's the truth. The real danger isn't a president having limited immunity for official actions. The real danger is a system where political opponents weaponize the legal system to go after each other every time power changes hands. Imagine a country where every former president is immediately investigated, prosecuted, and dragged through the courts by the next administration. That's not accountability, that's instability. That's a cycle of revenge that destroys trust in government. Now, does that mean there should be no accountability? Of course not. That's why we have impeachment. That's why we have elections. That's why we have checks and balances built into the system. But what we're seeing in this hearing is a push to redefine those boundaries, not based on law, but based on fear. And I'm going to be very clear here. Fear is not a good foundation for law. If you start crafting legal standards based on worst-case hypotheticals, you end up with rules that cripple leadership. You end up with leaders who are too afraid to act. And in a world where real threats exist, national security threats, economic challenges, global instability, that hesitation can be costly. So when I watch this exchange, I don't see a defense of democracy. I see a political performance. I see a senator trying to corner a nominee into giving soundbite answers that could be used later. And I see a nominee who, to his credit, refuses to play along. And that, right there, tells you everything you need to know. Because at the end of the day, this isn't about whether a president can do something extreme. It's about whether we're going to interpret the Constitution responsibly or distort it for political gain. And if we lose that balance, if we allow politics to override principle, then we're not strengthening the system. We're weakening it. That's my take. If you made it this far, drop a comment and let me know what you think. Do you believe presidential immunity is necessary for a functioning government? Or do you think it goes too far? Let's have that conversation. And don't forget to like and subscribe to Freedom Forge, because we're going to keep breaking down these issues in a way that cuts through the noise and gets to the truth.